Thank you, Mr. Chairman. Mr. Burt, I think it bears repeating something that Professor Turley referred to in your testimony, that Microsoft reviews the number of secrecy orders that federal law enforcement agencies have presented to us from 2016 to the present. We found that while the number has increased some, federal law enforcement has consistently presented us with 2,400 to 3,500 secrecy orders each year, or 7 to 10 per day. Is that correct?
Yes, that's correct.
That's an amazing number, and particularly when you try to imagine what that might be when you go to the other big tech firms. Professor Turley, you have a figure, and forgive me for this ignorance, but you have a figure in your testimony about, and you mentioned that national security letters have gone from 2000 to 2005, I believe it was, went from 8,500 to 47,000 per year.
That's correct.
And now, here's my ignorance. Would the secrecy order, Mr. Burt, that you're describing be the same? Would that include or overlap with national security letters?
No, Representative, it would be in addition to.
So that'd be separate, right? So in other words, a national security letter sort of there's similar concerns associated with that. That would be over and above what you're talking about, secrecy orders in connection with search warrants.
That's absolutely right.
And are those data published in the aggregate that you know about? You understand what I'm asking, Mr. Burt?
Yes, and the answer is there isn't any reliable source of that information in the aggregate. In fact, with regard to national security letters, we had to sue the government to be able to say anything about that, and the resolution of that was that we can only describe the number of national security letters we get in these broad categories. For example, I can report that, and we do transparently report, that in the last reporting period, twice a year, we got between 0 and 499, but that's the most specific we can be.
How about that? Fascinating. Professor Turley, you spoke about in your testimony, I'm afraid I didn't get your testimony before the hearing, so I haven't had occasion to digest it, but you advocate for a shield law. You mentioned the shield, one that's drafted, but you said that it needs to have the definition of journalist modified. As I skim through, it looks like you think there needs to be a broader definition of journalist. But isn't there, and this sort of goes to some of what Mr. Gates was saying, and I think Mr. McClintock responded to, about the possibility of setting up special privileges for an elite class. If journalists are partisan instruments of politicians, or the reverse, that is to say, they direct politicians in effect. If we establish special privileges for them to be able to take information and disseminate it that is by law confidential, doesn't that grant the power to unilaterally not nullify law? If you take the ProPublica information or recently, the disclosure of thousands of wealthy taxpayers, some which they've now selectively published, they said, they thought about it. They know this information is unlawful to publish, but they've decided that their advocacy interests trump the law. Mm-hmm. How do we deal with that problem?
Well, this isn't an absolute right. I mean, the media is subject, for example, to defamation. They're subject to being prosecuted for crimes committed directly by reporters. But what we're talking about is a constitutionally founded privilege. In the critical case of Brandsburg, the court heavily fractured over this question of privilege. There were some, like Douglas, who always believed we should have an absolute privilege. A number of the justices felt we should have a qualified privilege. In fact, most of the qualified privilege statutes are based on the language out of that case. And a qualified privilege just simply gives some added scrutiny and protection to the media. It can be overcome in extreme cases, but it's there to protect this core function of the media. If you take a look at the states, there's 40 states with these privileges. They haven't shut down prosecution. It has not been overwhelmingly burdensome. The judges have been able to use them. And I think the same would happen with the federal system as well.
In the 40 seconds I've got left, can you characterize what is the privilege, what are they privileged to do, and what are the qualifications upon that or conditions?
Well, what the privilege does is it basically gives a full stop for the court. Before you allow reporters to be compelled to turn over information, you have to establish that you can't reasonably get the information from another source, that you have a clear need for this information, where the court's going to balance these these interests. Some of these state laws are quite interesting. In New York, they have a different standard. If you go for privileged sort of core news stuff, you have an absolute privilege. If you go for less key material, you have a qualified privilege. There's a lot of states that have explored different types of approaches to this, and it gives you a lot of models to look at.
Thank you, Mr. Chairman.
The gentleman's time